So thank you so much, firstly, to Charlotte and Tree for organising this briefing session so that I could actually share some of my work on food GIs and also my recommendations for an Australian food GI framework. And thank you also to all of you for attending. That's really great to see. So just a little bit of background before I start. Um, oh, is that going to work? Trying to scroll through my slides. Let's try again. There we go. Just a bit of background on me before I start. I'm a commercial and intellectual property lawyer specialising in GIs, and I'm a consultant in this area. I also teach intellectual property and commercial law at the University of Adelaide. I completed my PhD in 2017, and that was conferred by the University of Adelaide in March 2018. And in my PhD, I explored the worth of using food GIs on food labels to make an origin claim in the context of a sui generis food GI framework in order to protect a couple of things. Firstly, the connection between Australian regional food and origin, and secondly, the assets that we have in Australian regional names that are used to identify authentic regional food products that have a clear and strong connection to Australian regions. One of the main reasons that I chose to undertake my PhD and research in this area is because of my IP practice background, in which I've carried out extensive work in trademarks and wine GIs as well. So I had always questioned why Australia doesn't have a dedicated GI framework that protects the connection between food and origin. And that's why I chose to focus on a sui generis food GI framework, because sui generis means dedicated. So a dedicated food GI framework is one that protects a food product that has a quality, reputation, or other characteristic that's essentially attributable to its geographical origin. And these are all key concepts of GIs as found in Article 22.1 of the TRIPS agreement, to which Australia is a member. So in order to understand how a food product's given quality, reputation, or other characteristic is essentially attributable to its geographical origin, and also how that connection can be protected pursuant to a dedicated food GI framework, I undertook substantive and original fieldwork in Europe and South Australia. In relation to the South Australian fieldwork, I chose the regions of Barossa Valley and Adelaide Hills for a few different reasons. Firstly, the reputation that both these regions have for producing quality regional food. Secondly, the value that exists in those regions and their names, and also the geographical features of the regions that do impact on food products' qualities, reputation, or other characteristics that come from those regions. I interviewed regional food producers and other representatives of the South Australian food industry. And the overall aim and objective of my South Australian fieldwork was to determine a couple of main things. The first thing was I wanted to find out from the interviewees if they were satisfied with current Australian laws and regulations that regulate the usage of Australian regional names on food labels to make origin claims. And the second thing I wanted to determine from the interviewees was whether or not they considered that Australia should implement a dedicated food GI framework and have something similar that we have for Australian wine GIs with the Australian wine GI framework. In relation to the European fieldwork, I chose Italy as a case study of a European country that's been operating under a dedicated food GI framework since 1992. Italy has 299 food GI registrations, which therefore makes it the country with the highest number of food GI registrations under the EU food GI framework. And so it was a perfect case study to determine the value of a food GI framework. I chose to focus on three main regions in Italy: Piedmont, Tuscany, and Emilia-Romagna. Again, for a few reasons. The first one being obviously the reputation these regions also have for producing quality regional food. Secondly, the value that exists in those regions and in their names. Thirdly, they have similar geographical features to Barossa Valley and the Adelaide Hills. And lastly, the food products produced in these regions, namely cheeses, meats, small goods, vinegars, olives, olive oils, and so forth, are very similar to the food products coming out of the Barossa Valley and Adelaide Hills. So similarly, I interviewed food producers in these regions who have been operating under the EU Italian Food GI framework since 1992. I also interviewed agricultural industry-based organisations and GI consortiums. And my overall aim really was with this fieldwork to determine if a food GI framework is effective to protect the connection between food and origin. Of course, I also wanted to gain some insight into what makes a food GI framework workable. Could I pick up on any, special elements that would be needed for a successful food GI framework? So overall, the South Australian fieldwork revealed that the interviewees are interested in a dedicated food GI framework. They do want to see a similar framework implemented for the food industry as the Australian wine GI framework. It provided really valuable insight into the elements that the interviewees thought would be essential for a successful food GI framework. The details and findings of my South Australian case study are actually due to be published in September this year in the Australian Intellectual Property Journal. The Italian fieldwork revealed that a dedicated food GI framework is also an effective framework to protect the connection between food and origin. It provided valuable insight into the elements required for a successful framework. However, I am not recommending that an Australian food GI framework replicate the EU Italian food GI framework. Rather, I am recommending that an Australian food GI framework has to be tailored to accommodate Australian food industry, trade and intellectual property needs. So today I'm going to focus on explaining to you the case that exists at a national level for the implementation of a food GI framework, and then also the case that exists at an international level. The current rounds of negotiations between Australia and the EU in relation to the FTA provide a conduit for our consideration of a framework that protects the connection between Australian regional food and origin, and also the assets that we have in Australian regional names that are used on food labels to make origin claims. As just mentioned, the South Australian fieldwork disclosed that the interviewees would like to see a similar framework implemented for the food industry as exists in the wine industry, thanks to the Australian Wine GI framework. As you would know, Australia has had a dedicated wine GI framework since 1994. Wine Australia regulates the wine framework pursuant to the Wine Australia Act 2013, the Wine Australia Regulations 2018, and the Label Integrity Program. Its existence since 1994 proves that we can work with the GI framework, and we can also develop GIs that are valuable. Since its inception, the wine framework has placed the wine industry a step ahead of the food industry. And that's because the framework provides clear ex-ante guidance to grape growers and wine producers that they must ensure that at least 85% of the grapes that they use to make wine labelled with a GI come from that GI area. It regulates that wine is connected to the GI area in this manner, and obviously there are other regulations. This is just at a simple level before a wine GI can be used on a wine label. So the guidance and regulation provided pursuant to the Wine GI framework is much clearer than that is currently provided to Australian food producers and traders across a patchwork of laws and regulations. The patchwork of laws regulating origin claims made on food labels fall into these three main groups: consumer protection laws under the Australian Consumer Law set out in Schedule 2 of the Competition and Consumer Act 2010, passing off and extended passing off at common law and trademarks law under the Trademarks Act 1995. I have analysed each of these and I've found that they are deficient. They are inadequately protecting the connection between food and origin, as well as the value that exists in Australian regional names used on food labels to make origin claims. They are deficient in the following three main ways. The first is they allow food producers and traders to use regional branding, so that's using regional names on food labels to make an origin claim, that falls short of being misleading or deceptive or involving passing off, even though the food has only a weak connection with the name region. Secondly, they don't give regional food producers enough ex-ante guidance as to when they can make an origin claim on food labels and products, especially if some of their ingredients are sourced or some of their food production is taking place outside the named region. Third, they don't adequately regulate whether there is a clear connection between food and origin before a regional name can be used on a food label to make an origin claim. So for example, regional name to make a place of origin or credence claim on a food label, they are subject to the general requirement of accuracy, that is not being misleading or deceptive, which is imposed by the Australian consumer law. The onus is on food producers and traders to ensure that they comply with this general requirement of accuracy and that they can substantiate the claims they make on food labels. This normally involves food producers including actual place of production information on their food packaging. Unfortunately, the ACCC does not regulate whether food producers comply with this requirement before they use regional names on food labels to make place of origin or credence claims. Rather, the ACCC and consumer protection laws rely on food producers and traders to ensure that they make accurate claims. It's only where a complaint is made about a place of origin or credence claim, and if that complaint is taken further and investigated by the ACCC, that the ACCC steps in and regulates whether a food producer has complied with the general requirement of accuracy. This is inadequate regulation and inadequate protection of the connection between Australian regional food and origin. Furthermore, problems arising from these deficiencies with our current laws means that food producers are able to take advantage of and also free ride on the reputation that Australian regions have for producing quality, authentic regional food products, as well as the value that accordingly exists in these regional names. So the usage of regional branding and free riding by food producers is causing four main problems. The first one is Australian consumers can't rely on or trust food labels that include regional branding to obtain accurate information about regional origin of food products. So many food producers and traders are using regional branding on food products to make an origin claim, notwithstanding that their food products lack a clear and strong connection with the region claimed. In many instances, food labels that include regional branding fall short of being misleading or deceiving because the actual place of production of the food product is disclosed elsewhere on the food label. However, this does not overcome the lack of connection between food and origin claimed on the front label of the food product and the associated problems that arise from such usage of regional branding. This is a significant deficiency of current Australian consumer protection laws, particularly pursuant to the place of origin labelling framework. Secondly, regional food producers are being deterred from making additional investment in producing regionally branded food products. If any food producer is able to use an Australian regional name on a food label to make an origin claim, notwithstanding the lack of connection between their food and the region claimed, what is the incentive for regional food producers? What incentives are they provided in recognition of the time and money they invest in producing quality regional food products, in increasing the value in their regional names and in increasing the reputation of their respective regions for producing quality regional food. Third problem, the value that exists in Australian regional names is not being adequately protected. Australian food producers and traders realise the intangible value that exists in using Australian regional names on food labels. This value exists primarily because the provenance of food is a substantive issue for many consumers. There is significant consumer demand to have correct and specific information about regional origin of food included on food labels. However, due to the deficiencies of current laws and regulations, the lack of regulation of connection between food and origin is impacting on the value that exists in Australian regional names, as in many instances, they are used on food products that lack a connection and also used on food products that have varying degrees of quality. So this undermines the overall value in regional names and can also impact on the reputation that regions have for producing quality regional food. Lastly, Australia risks losing the assets that it has in Australian regional names, and that has the potential to affect our regionality. Australian regional names are often used on food products that are made outside of Australia to denote an origin claim. This is notwithstanding that in many instances, the food products have no connection with the region claimed. In many instances, the usage of regional branding by internationally based food producers also falls short of being misleading or deceiving because the actual place of production has been disclosed. But this is notwithstanding that the food product has no connection with the region claimed on the label. This therefore has the potential to affect our regionality and also our food, agricultural and agri-food industries. To further understand the deficiencies of current laws and regulations in this area, it's also useful to review some practical issues that arise out of trademark laws. Trademark laws, as you know, are concerned with ensuring that trademarks are distinctive and act as badges of origin of those who produced food products in relation to which the trademark is used. They are not focused on regulating whether there is a connection between food and origin before a regional name can be used on a food label as part of a trademark, and they are not badges of origin that typically identify regional origin of food products. This is highlighted when standard trademark applications that include regional names that are going to be used on food products are examined pursuant to sections 41 and 43 of the Trademarks Act. The following issues may arise. Firstly, under section 41, the reference to consists wholly of is a reminder that where the trademark includes a distinctive logo or is presented in a way that is striking or unusual, the trademark could be accepted for registration, notwithstanding that it also includes a geographical name. An applicant could apply for a composite trademark or file evidence of use to show distinction in fact. A composite mark might overcome the distinctiveness issue and therefore result in a registered trademark being used on food products that contains a regional name, notwithstanding that the food product has no or very little connection with the named region in the trademark. Section 41 doesn't regulate whether there is a connection between food and region, but rather the distinctiveness of the trademark overall. Secondly, under section 43, the focus is on connotations. The presence of a regional name on its own that carries a connotation about the geographical origin of the food product to which the trademark attaches doesn't mean that section 43 will automatically apply. Rather, the trademark is examined as a whole. So there needs to be a real and tangible danger that the consumer's expectation that the food product is somehow connected to the region being claimed in the trademark may turn out to be false to trigger section 43. So a mere possibility of confusion or suggestion of deception is not enough. If there is a real and obvious danger of confusion caused by connotation, then in some instances, to avoid rejection under Section 43, a condition or endorsement might be added to a trademark to ensure that goods are actually produced in the place nominated where the trademark does meet that high threshold. Endorsements are typically needed where a consumer would reasonably expect the goods to originate from the reference in the trademark. If a geographical reference is obvious, direct, and immediate within the trademark itself, such as grown in, produce of, and has a connotation relevant to the particular goods, then these would be taken to be likely to deceiving or causing confusion. However, if there is no real and obvious danger, then trademark laws can allow trademark registration of trademarks that include place names on basis of fairly sparse evidence of acquired distinctiveness and by a rather subtle reading or application of Section 43. For example, as can be seen in this trademark, Barossa almonds, the Barossa geographical connotation is dispelled by a logo, device, and other words used in the trademark, taking away the prominence of the word Barossa. The trademark has been accepted for registration, notwithstanding that the almonds lack a connection with the Barossa. They are made in Virginia, which is 50 kilometres away from the Barossa Valley. Furthermore, elsewhere on the packaging, which probably isn't totally clear, but in this section of the label, it's actually disclosed where the almonds are produced, namely in Virginia, taking it away from being misleading or deceiving as to origin of the almonds. So overall, it's clear that sections 41 and 43 of the Trademarks Act are really more about consumer perception, connotations, distinction of trademark, rather than regulating that a trademark that includes a geographical name that is going to be used on a food product is attached to a food product that does in fact originate from the region claimed. When there is no real and obvious danger of the public being deceived or confused, the trademark won't be opposed. Furthermore, when considering opposition and defences available pursuant to trademark laws, the following issues may arise. Firstly, pursuant to Section 88, subsection 2, a trademark can be rectified on the trademark register if it can be shown that a trademark is likely to deceive or cause confusion. But once again, the test is a high threshold because there needs to be a real tangible danger before it will be treated as likely to deceive or cause confusion and in need of rectification. Secondly, pursuant to Section 120, good faith defences allow trademark owners to use descriptive terms such as geographical names as long as there is a logo, a device, or no real and obvious danger of consumer confusion. If they use the regional name in good faith and have disclosed actual place of production, then that's likely to be enough to be accepted for registration. Moving away from standard trademark applications to certification trademark applications, CTMs can certify geographical origin of goods and quality of some other characteristic. However, the application process to obtain CTM registration is rather onerous and expensive. Moreover, CTMs offer limited protection. They are private rights that mandate how the owner, normally an association, and authorised users need to use the CTM and any requirements of origin. CTMs therefore only certify the geographical origin of and provide protection to the food products that are the subject matter of the CTM. They provide protection and certify origin of food in accordance only with the rules relevant to that CTM. They govern the use of the CTM that includes a geographical location name, not the usage of that geographical location name generally. That means that CTMs don't stop other food producers from using the same geographical location name on their food products, or obtaining trademark registration of a mark that includes the same regional name. CTMs don't mandate how others might use that same name as part of their regional branding or a standard trademark. They only mandate how the association and authorised users need to use the name and any requirements of origin. So the protection offered by a CTM is quite specific to that group. The connection between CTMs relating to food and geographical location named on the CTM is contextual. It's subjective within the ambit of the rules of the CTM. They are not broad protection measures. At a practical level, CTMs aren't widely used by Australian food producers, associations to certify geographical origin of food. In an international context, traditionally, Australia has merged GI protection for all products, other than wines and grape products, into existing trademark laws using CTMs on two main bases. The first one is that both trademarks and GIs serve a similar purpose because they are badges of origin. And the second one is the trademark framework is already in existence and is familiar. However, both of these bases can be challenged. First, while trademarks and GIs are both badges of origin, as already discussed, a trademark that includes a regional name that is used on food labels does not typically identify that the food product has a clear and strong connection with the name region. Whereas a regional name that is a registered GI and is used on a food label does identify food products that have a clear and strong connection with the name region. This is because a GI is a sign that identifies a link, a connection between product and place, rather than a sign that is a badge of origin of who produced the product. Unlike CTMs, GIs are descriptive of goods' geographical origin based on delineated GI boundaries and prescribed rules. GI frameworks strictly regulate that GIs are used only on goods that originate from the GI area and that accord with GI criteria. GIs are a public right available to food producers located within the GI area, and rules are mandatory across the board. A GI that is registered as part of a dedicated GI framework provides a high level of protection that isn't offered by trademark protection. Any use of a GI on a product that doesn't originate from the designated area or doesn't comply with the specific GI criteria is ipso facto automatically an infringement. There is no requirement to prove that the usage is misleading or deceiving, and no trademark defences such as good faith apply when a GI is misused. Now, Australia is already familiar with these high-level GI protection rights, given that they exist pursuant to the Australian GI wine framework. Therefore, the second ground for protecting GIs as part of Australia's trademark framework is also undermined. Using CTMs to protect GIs rather than implementing a dedicated GI framework to protect GIs, because the trademark framework is already established, familiar, and therefore provides budgetary and administrative benefits, is not a justifiable basis for merging GI protection into the trademark legislation and framework. GIs and trademarks are not the same thing. So as just mentioned, the Australian Wine GI framework already differentiates between GIs and trademarks and provides higher protection for Australian wine GIs than what those regional names would otherwise be afforded pursuant to consumer protection or trademark laws. Wine Australia, pursuant to the Wine GI framework, regulates that wine is connected to the region claimed before an Australian wine GI can be used on a wine label. It provides clear rules regarding description, presentation of wine. It makes it clear that it will be false, misleading, and deceptive if a GI is misused. even if it indicates the country, region, or locality in which it is produced. Therefore, no disclosure of actual place of production or good faith defence is available for GIs. If a wine GI has been misused, that's enough to require protection pursuant to the wine GI framework without the need to prove the usage was misleading or deceiving. So for these reasons, consumers are able to trust wine labels that include wine GIs to identify from which Australian region their wine originates. GI protection surpasses protection and regulation provided to Australian regional names under other laws and regulations. Given this differential treatment afforded to wine GIs in Australia and the differences between GIs and trademarks, as well as the deficiencies and problems highlighted with consumer protection laws, I recommend that a food GI framework is an ideal mechanism to overcome these deficiencies and problems I've highlighted. A food GI framework would provide more automatic protection to the connection between food and origin than currently available under Australian laws. It would provide regions and food producers with more effective legal means to protect their regional branding and the reputation that their regions have for producing quality regional food. Any use of a regional name in the form of a food GI on a food product that is not connected with the region would automatically be an infringement pursuant to a food GI framework, just as it is pursuant to the wine GI framework for wine GIs. So a food GI framework would thereby protect the value that exists in Australian regional names. It would also provide one practical, effective legal framework dedicated to protecting the connection between food and origin, rather than trying to provide the protection across multiple frameworks, multiple patchwork laws and regulations, which is very confusing for food producers and consumers. The recommendations that I make for an Australian food GI framework include the following. The framework must be tailored to Australian food industry and trade needs. It should have 2 levels of GI protection. It needs to make boundary determinations that are relevant for food GIs. It needs to have cost considerations. It should be regulated by one main body. It needs to be collaborative and inclusive. It needs to have a rollout period to cater for conflicting business names and trademarks. It also needs to have an education rollout for food producers and consumers. I've included extensive detail on all of these in my recommendations for an Australian Food GI Framework publication that's been published on the DFAT website under the submissions received in response to the Aus-EU FTA, and refer you to that for further information. I will just touch on a couple of these here. Firstly, a dedicated food GI framework must be implemented with careful forethought and consideration over about how to overcome deficiencies of current laws and regulations at a national level to provide adequate protection to the connection between food and origin, and to also cater for Australia's international GI trading needs and obligations. In determining the potential worth of food GIs and a dedicated framework, I've considered national and international laws, intellectual property, trade, political and cultural issues. The second one that I will touch on is these 2 levels of GI protection that I'm recommending to regulate connection between food and origin. I'm proposing that a food GI framework have 2 levels or tiers of GI protection for food products. The first one would be a basic level GI protection for food products that are made within a region and made using locally sourced ingredients. And then the second is a higher level GI protection for food products that are also made within a region and made using locally sourced ingredients, but that also have a quality, reputation or other characteristic that is essentially attributable to their regional origin. So for both these tiers or levels, the following 2 criteria would need to be satisfied. The first one I'm recommending is that core ingredients must be locally sourced from the GI region. So a food GI framework should prescribe a percentage of core ingredients that need to be locally sourced from the GI region for the purposes of providing clear ex-ante guidance on this criterion to food producers and traders. This would be similar to the regional origin of grapes requirement pursuant to Regulation 26 of the Wine Australia regulations that prescribes that if the description and presentation of wine uses one registered Australian GI, then at least 85% of the wine must be sourced from grapes grown in that registered GI area. So I'm recommending that a standard percentage be included in the food GI framework for all food products, rather than different percentages for different food products. However, this would need to be determined in consultation with regional food producers. The field work I carried out did underscore that core ingredients must come from the region and that is doable in most situations. The second requirement that I'm recommending is that a certain percentage of the regional food product must be made within the GI region. This criterion also reflects the fieldwork that revealed that in some instances, not all stages of food production can take place within a region. That might be because of laws or council regulations that don't allow for some stages to occur within a region. However, I recommend that a certain percentage of the food products production stages must occur within the GI region. Having such a requirement mitigates the risk of food producers using a food GI on their food product when most or none of the production stages of their food products takes place within a GI region. So a standard percentage would need to be included, again, rather than different percentages for different types of food products. This, of course, would also need to be determined in consultation with regional food producers. To obtain the second level protection, those two criteria would need to be satisfied. And in addition, the third criteria, regional food has a quality, reputation, or other characteristic that is essentially attributable to its regional origin. So, for example, a food product might be made using traditional processes and methods that are unique to a region. So in the Barossa, there is a traditional recipe, curing process and smoking method that is used to make small goods. It's important, though, that for this third requirement, the processes and methods are traditional to the place of origin claimed and that they can't be replicated in another region to produce a similar food product. Otherwise, that will undermine their connection to the region being claimed. So, what would a food GI framework bring to the Australian food industry? Well, firstly, it would assist the food industry with catching up with the wine industry by bringing the protection of Australian regional names used on food labels to the same level as that currently provided to Australian wine GIs used on wine labels. Importantly, having a dedicated framework would ensure effective regulation of whether there is a connection between food and origin before food producers and traders can use regional names on labels to make origin claims. It would also mean that food producers and traders would be complying with one legal framework rather than three different areas of laws and regulations. This would ultimately provide incentives for regional food producers to invest time and money in making regional food products, knowing that the value in their regional name is being protected, as is the reputation in their region, and that their food GI is available to be used only by food producers complying with the food GI framework requirements. And so overall, it would provide for better protection of the value that we have in Australian regional names. So that pretty much explains the strong national case for a food GI framework. But in addition, of course, there is also an international case for a food GI framework. As I mentioned at the outset of my presentation, the current rounds of negotiations regarding the Oz-EU FTA present an opportunity for us to consider the importance of food GIs for Australia. They also provide a conduit for us to consider the worth of implementing a dedicated framework. As already mentioned, in an international context, we currently provide protection of GIs for food products as CTMs. However, as also explained, given the differences between CTMs and GIs, as well as the higher level of protection that GI frameworks provide GIs than trademark frameworks, the EU is seeking this higher level protection from Australia for the EU GI names pursuant to the FTA. And of course, you know, the EU has been negotiating similar FTAs with many of Australia's trading neighbour countries and has successfully concluded FTAs with Singapore, Japan, and also further away from home with Canada. So many of Australia's neighbouring countries, including China, Thailand, Japan, Malaysia, India, Vietnam, Indonesia, and Singapore, are also now seeking to trade with countries that provide food GI protection pursuant to a dedicated framework, so to achieve the same high level food GI protection at an international level as provided pursuant to their national frameworks. This impacts on Australian food industry and food producers in the following ways. First, there's an increased demand to protect food GIs at a higher level in international trade from neighbouring countries. Second, FTAs that EU is entering into with our neighbouring countries have the potential to impact on the food terms that Australian food producers can use on foods that they export to those countries. Thirdly, the absence of having a dedicated food GI framework in Australia sets potentially strong limits on the present or future protection of Australian food exports to Asia. By failing to implement a food GI framework, we still run the risk of losing the assets that we have in our regional names if internationally based food producers can continue to use regional names on food products which lack a connection with regions because actual place of production is being disclosed. Let's look more closely at some of the FTAs that the EU has completed to gain some insight into what has been protected and also how these outcomes might be of assistance to Australia in its negotiations with the EU regarding food GI protection. So firstly, CETA provisionally entered into force on the 21st of September 2017. It protects 143 EU food GIs. Canada actually had protection for wine and spirit GIs 20 years prior to CETA, so it already had a wine spirit GI framework, but as a consequence of CETA, it's expanded its GI protection to 24 categories of food and agricultural products and now has 170 protected Canadian food GIs. There are a number of exceptions that apply to the protection provided to GIs pursuant to CETA, some of which Australia would be interested in given negotiations with the EU for some similar EU GIs. So some of the exceptions are, obviously, if the GI is a term customary in common language in Canada for food. There are exceptions for terms such as Asiago, Feta and Fontina, allowing those GIs to be used with qualifying terms such as kind, type, style or imitation, if the geographical origin of the cheese is clearly displayed on the cheese or packaging. Some of these EU GIs can also be used if they have been used in Canada in connection with cheeses predating 18 October 2013. Also, there's exceptions for common food names, generic terms, such as Valencia, Parmesan, Black Forest ham under CETA. GI protection has been offered via Canada's trademark framework rather than implementing a dedicated GI framework. Bill C30 was introduced in 2017 to allow for changes to the trademark framework to cater for more extensive GI protection agreed pursuant to CETA. However, really important to note that since its inception in 2017, there have been ongoing suggestions and recommendations made that without the implementation of a Canadian dedicated food GI framework, GI-related amendments to the Canadian Trademark Act favour selected EU GI products and not Canadian interests. And so that's also an important consideration for us to have a think about options on how to cater for GI protection. So recommendations have been made that Canada consider a dedicated GI framework to take full benefit and advantage of protecting Canadian GIs. And they are looking at countries such as Japan and India as examples of countries that have a dedicated GI framework that is allowing them to take the full benefit of GI protection. Moving on to Japan, EU and Japan's Economic Partnership Agreement entered into force in February last year. It has got similar protections as those, exceptions as those made under CETA for EU GI protection. These again include where the EU GI is a term customary in common language, a common food name, and generic. So for example, the individual component camembert of the multi-component GI Camembert de Normandy is not protected given that it is a generic term. Furthermore, similar to CETA, some EU GIs can be used in Japan with qualifying terms if the place of production is disclosed. So for example, Kalamata can continue to be used on similar goods, provided that the consumer isn't misled on the nature of such term or the precise origin of the good. Japan was pro-protecting GIs before the EPA with EU. So already had in place a GI framework. It came into force in June 2015. It came about because Japan does have regional branded food products that are high quality and that do have a reputation as a result of unique production methods and also characteristics of the production area such as climate and soil conditions. So Japan also places significance on GIs and trading with countries that do offer high-level GI protection at the same level that is offered to Japanese GIs pursuant to the Japanese national framework. Again, an important consideration for Australia, given Japan is our neighbour and also trading country. Going on to Singapore, EU and Singapore have also negotiated an FTA, an investment protection agreement. They also came into force in November last year. They protect approximately 190 EU food GIs, and there's to date about 100 Singaporean food GIs registered as well. There's actually a dedicated GI registry established in Singapore in April last year that protects the EU GIs, Singapore GIs, and also other country GIs as well. Registered GIs are entitled to protection against unauthorised use, even if such use doesn't mislead the public as to the true geographical origin of the goods. And again, I think this is important because it's showing that Singapore is also placing greater emphasis on GI protection at a higher level than offered pursuant to CTMs. Lastly, New Zealand and EU, which we all know is in negotiations. The 8th round completed in May. GI public consultation period ended in March, and those objections are now being reviewed. Quite similar in tracking to date between the negotiations that are taking place with Australia and EU, in the sense that similarly, EU is seeking protection of approximately 2,200 EU GIs from New Zealand. It's agreeing to protect qualifying existing New Zealand GIs that are nominated by New Zealand. Similar as well in that New Zealand already has a wine GI framework and has had it since 2006. And again, similar because for all other products, including food, New Zealand currently protects food GIs via consumer protection laws and trademark legislation. Where I think New Zealand is a step ahead to Australia for GI perspective is the Treaty of Waitangi. So given the Treaty of Waitangi's existence, New Zealand has made it clear in its GI negotiations that it wants to understand the view of Maori as a Treaty of Waitangi partner, both in relation to the potential benefits of an expanded GI framework, as well as any costs or risks associated with such an expansion. And consequently, the way 262 report was created that looks at the interplay between intellectual property rights and Maori rights. Now, it doesn't make any specific recommendations in relation to GIs, but it has been noted that the potential use of GIs to protect names from Te Reo Maori associated with certain products from particular places is important. However, the tribunal has also noted GIs only provide an indirect mechanism to protect any kaitaki relationship associated with those place names and products, and that it is the kaitaki relationship that deserves protection, not the GI isolated from that relationship. So this is actually a really interesting area and a wider ramification and research interest of mine, looking at GI protection for Australian Indigenous ingredients as well. So I will be doing more work in this area, so please watch this space. But just to finish off the New Zealand and EU FTA, potential frameworks discussed either a standalone registration regime for food or an expansion of New Zealand's GI framework. So just to finish off, it's evident that food GIs are also important trading negotiation issues at an international level. And I think that just reinforces again the case for considering the implementation of a dedicated GI framework. As mentioned, the Oz-EU FTA negotiations present an opportunity for us to consider the worth of implementing a dedicated food GI framework, not only, I suppose, in response to the concessions that are being asked of us to be made by the EU, but very importantly, because of the need that exists at a national level for a framework that effectively regulates and protects regional names and the connection between Australian regional food and origin. The negotiations also provide us an opportunity to consider whether there are Australian names that we would like protected from the EU as food GIs. So the current negotiations provide an occasion for policymakers to work with local food producers, entrepreneurs in developing connections between places, products, local Australian culture. I think by thinking locally in terms of our distinctive regional qualities and implementing a food GI framework that protects our regionality and our regional names, we could act globally in seeking GI protection worldwide for Australian food GIs. And that's an exciting development that could have far-reaching consequences for our food industry and for our food producers. There is more information on everything I've discussed in some of my publications. So as I said before, my recommendations for an Australian food GI framework publication is available on the DFAT website, as is another 2 documents, frequently asked questions about food GIs and their worth for Australia, and my executive summary. So they're all on the DFAT website under the submissions received for the Oz-EU FTA. And then in addition to those, also the series of articles in the Australian Intellectual Property Journal about regional branding on food and wine labels, which gives you a bit more of a overview about deficiencies with current laws and regulations in this area. That's it from me. If any of you look at my publications or have any other questions, the very last slide, which I think you've all got copies of, includes my contact details. So I'd be happy for you to email me with any questions or issues. Also happy to follow up with, another presentation if there's a particular area or component that I've discussed today that you think, it would be good to have further information on as well. So happy to do that.